Hey y'all, I'm Karen Mayer Cunningham, the special education boss. If you've ever felt confused, overwhelmed, or just plain frustrated at the 504 IEP table, you are in the right place. Every week, I'm breaking down the rules, the rights, and the realities of special education so you can walk into meetings informed, empowered, and ready to make real change. And whether you're a parent, a teacher, an advocate, a school-based member, or somebody who's just trying to do right by a student, this podcast gives you straight talk, real answers, and tools that you can use immediately. I'm not here to play politics. I'm not here to play sides. I'm here to train people who sit at the table and teach you how to follow the law, ask the right questions, and protect the rights of students. So go ahead and hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change. We're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody. Welcome you guys back to our series, All Things Special Education. We're super excited to have an amazing guest on tonight. We have the great Maria McGinley. Maria, welcome.
Thank you so much.
She is a fancy special education attorney doing great things in New York and surrounding areas. And we are excited to have her on and talk tonight about, the purple elephant, right? The due process that you hear about. You don't usually hear good things or you hear bad things. And so we wanted to give you guys an opportunity to be able to ask questions about that from an expert. But before we get to that, Maria, thank you for being on. Can you tell us a little bit?
Thank you so much for having me.
About your background, how you got to be in law.
Certainly. So in my prior career, I was a special education teacher. I taught students with autism. I taught students with really almost all of the classifications in various settings. And while I loved being a teacher, I struggled really almost every single day with seeing students who were not appropriately placed, were not receiving the right services. And so that pretty much compelled me to go to law school. And I went in pretty much knowing I wanted to go into special education law. So I have been doing that now for quite some time. And subsequent to that, I also have two children, one of whom has been through the IEP process. And so I have kind of that unique vantage point of sitting at the IEP table as a special education teacher, and then as an attorney, and also as a parent myself.
So just kind of piggybacking on what you said, I see this a lot, that special education attorneys, whether they end up being attorneys that represent the parent or the school district, are often literally out of the education system. So tell me how that works.
Sure. So I think that is true. Quite a number of my colleagues, whether they were special education teachers or ABA therapists or in a different role, I think a lot of people recognize that while there are many school districts that are doing right by many students, there are also many students who are not receiving the free, appropriate public education to which they're entitled. And that becomes a compelling force to recognize that advocacy sometimes is better postured for some individuals from a legal vantage point as opposed to being the educator at the IEP table. That's not always true, but that can be the case and can compel some people to go to law school.
So when so you're a teacher and you just decide, at night, I'm going to go to law school. It'll take 10 minutes. Kind of walk us, how does that process work? Because often we have many amazing educators here that are ready to just pivot to a new career or grow in their career, especially with their love of special education. So kind of tell us what that looked like.
Sure. So the pivotal moment, I was toying with the idea for quite some time. I was toying with the idea of law school even before becoming a teacher. So it was the seeds were already planted, if you will. But I sat in a meeting where someone from the administration pretty much told the staff that services were not being provided, and that if parents brought up questions at the parent-teacher conferences, that we should direct them to the administration and not explicitly confirm that the services weren't being provided. That was enough. The law school applications were gathered the next morning and completed. And then from there, I actually did decide to go to law school part-time. I was an evening student. I continued teaching for the first 2 years of my law school journey, and then pivoted to more legal roles so that I'd be ready to kind of hit the ground running. And while it's certainly not an easy journey to take, it was fueled by my desire to really want to get in there. And so having that kind of eye on the prize and knowing ready where my journey was going to take me was enough to make a full-time teaching job and a part-time evening law school job manageable, thankfully.
And that's amazing. And, I live in a state with just 5.5 million children in school, 800,000 on IEPs. And even in Texas, we only have 6 or 7 full-time special education attorneys for parents. Why do you think that is?
I think that could be for a number of reasons. Every jurisdiction and every state has a different reputation, if you will, for what due process looks like, what advocacy looks like, not necessarily access to resources from a financial standpoint, but looking at the process and what that process looks like. I mean, when you have jurisdictions like ours in New York City, there are so many children from all walks of life, from all of the 5 boroughs, who are deprived of a FAPE. And there is a tremendous amount of advocacy in New York City to be able to navigate for those families. But there are you go across the bridge to New Jersey, and I have many friends in New Jersey that say, why don't you come here? Why aren't you litigating here? We need special education attorneys. And so I think there are a lot of factors that play into that, but certainly there are jurisdictions that can be a lot more challenging to bring due process proceedings.
Right. I always say that I think it's, what is it, something like 32 or 33%, this is a while back, of families prevail in due process. And there's many reasons for that. And I always say, I think Texas is like -4. And it's just the way, it's not a jury. It's not a jury of your peers. It is one person who probably their view is mostly educators or education, right? And the parents have to prevail. So kind of talking about due process, and we'll talk about the other dispute resolution options. I think it's interesting that it's called the free appropriate public education, and we have the right to due process. And certainly parents can file themselves, which we rarely see that be successful. So kind of before you due process, kind of taking apart the what I call the 6 dispute resolution options, and when you would recommend that people use them. So one is a district grievance, which I usually say is a waste of time, although I've seen it be very effective from somebody that wasn't in the district. Do you ever have occasion to direct your clients or associates to use that pathway?
So I'm going to preempt the question by saying we're always looking at the right course for clients to take. And advocacy should always be the first go-to, right? So even before we're at the dispute resolution point, it's looking at what else potentially can be done to avoid having to take further steps. In terms of an actual grievance, that's not something that we're typically using, but certainly in our cases, we're looking at, is there a resolution meeting? I mean, ironically, I know you've spoken about resolution meetings in your other podcasts, but yeah. While resolution should be happening, a lot of our families in New York City don't even get a resolution meeting at all. And so if the parties aren't coming to the table to attempt to resolve things, that already puts you in a precarious spot. But there's mediation. There are other ways in which you can try to explore that. I think every jurisdiction is going to look different in terms of how effective that is. But I think the eye should always be towards attempting to resolve before actually filing for due process, for sure.
Right. And I think what parents don't realize is no matter who makes a decision, no matter who's the fact finder, whoever it is, you still have to go back to the table, right? A lot of people
Sure.
think, oh, well, Bob, the hearing officer said this, so it's done. No. We have to go back to the same table. So can you talk a little bit about that?
Absolutely. So I think some of the parents who come to us who are afraid or apprehensive of going to due process recognize that. And they say, listen, my child is in this public program. My child needs A, B, C, and the district just isn't providing it. And if they go to due process, they're still going to be in that same school setting. They're still going to have the same teacher. They're still going to be with the same students, right? It's A, B, and C that you're fighting over. But at the same point in time, what I also think is a point that parents don't always immediately recognize is that due process isn't about fighting your school district. It's not about winning this battle. It's about getting your child what your child needs. And that can happen simultaneous to going back to that table and having that subsequent IEP meeting and recognizing, yes, you may have went to a hearing, and regardless of how that prevailed, your child is now a year older. Your child's needs may continue. Your child's needs may be different. There may be new needs that are emerging, and that conversation needs to continue happening.
Yeah. So so when we get to due process, obviously I love mediation. I love that it's, all of us can walk away or not. Nobody has to do anything. You're not bound by anything. I think it gives both parties great liberty. I think often we have mediation, we get to tell our story in front of somebody that we haven't been in front of, right? An assistant superintendent, a special education director. My heart and my hope is that there is somebody in the district, city, or county that wants to listen to your story. And so often that's a great way to resolve it. But of course, those components, dispute resolution session and mediation, that hearing officer is going to want you to participate in those anyway. So let's say that we went through the mediation, went through the dispute resolution session. We just see things differently. Kind of walk us through what that looks like, other than, a lot of people are like, we're just going to lawyer up. I'm like, oh, that's not a real thing in Texas, right? Because you're not suing the school district. That sounds good. It actually is your disabled child files against the school district. So generally walk us through what that process is and the pros and cons of each step.
Sure. So I think when we're meeting with a new client family and we're talking about their child and their child's needs, we're looking at, is there a way to solve the problem through advocacy? Or do we need litigation because the problem isn't being solved? And we work with families who are on both sides of that coin, right? And the approaches can be very different. But for the families that need to go the due process route, we are counseling them on all of the steps that they need to be taking. There's a lot of things that need to be happening. First and foremost, I would say, parents need to have a very real understanding that this is an emotionally draining process when you go to due process. This is not Law and Order. We turned on TNT and we're watching Jack McCoy litigate a case. This is an administrative trial that you will need to participate in, and your lawyer will be cross-examining witnesses. Your lawyer will be calling your own witnesses. You'll be there hearing everything, and that takes an emotional toll. There is obviously a financial toll that it takes on families. And you also want to recognize that at the end of the day, your child is at the heart of everything. What does your child need? Who is saying what your child needs? What is the school district saying? And a lot of times parents say, well, I went to the IEP meeting. They say my kid is doing okay. They say my kid is making progress. They say everything is just fine. And it's also about educating families about how to participate in that meeting, how to ask the right questions, asking open-ended, provoking, but not provoking questions that gather information and that gather data. You're saying my child is making progress. What are you relying upon? Can you explain what you mean by that? Can you give me some examples? Can you describe what that looks like? And listening to those responses is one way to gather information. Obviously, the documentation is critical. So that can look like formal reports, evaluations, progress reports, report cards, things of that nature. But also it can look like the correspondence and the paper trail that you've created, because sometimes we think our memory is going to be great, but it's not. A paper trail is evidence. Your memory is not. And so if you feel that something happened and that is a deprivation of FAPE, it is not appropriate, documenting it is creating evidence that you can use. So it's a matter of, kind of from a higher level, going through, really walking through, getting to know, who is this child? What has transpired? What has the district done? What has the district not done? And where are the points that we need to be compiling our facts to support the narrative? Because what you said earlier is really powerful in due process as well. And you said, I love going to mediation and I love telling the story, right? And with the hope that it's going to fall upon ears that are understanding, et cetera. But the same is also true with due process. It's getting the whole story together, and we can make up arguments and we can be persuasive. But at the end of the day, the facts are telling what has transpired. The facts and the evidence are what the impartial hearing officers are going to look to when they're rendering their decision.
Yeah. And so talking about that, I always say that evidence or data, if you can't screen share it, it's not a thing, right? So, and often people are like, oh, I'm going to get to tell my story, but that they don't get to take the stand and then talk for 2 hours about all the things, right? And so it is about, I always say that my paperwork should speak for itself when I'm not there, right? A lot of people say you take so much time in the present levels, you take so much time in the progress reports. Correct. Because most parents are trying to get to the schedule of services page, desert. But the need and the requirement and the obligation and duty exist in the present levels and evaluations. So when you're preparing a family, obviously all of these pieces are going on. It's interesting that you said it takes an emotional toll. I had a family that I represented through in due process, and they literally got divorced in the middle of due process. And I'm like, oh my gosh, she's like, oh, you're doing great. I'm like, it is such an emotional toil because everything that you want to say doesn't get said. Every question you think that your attorney should have said doesn't get said. And kind of, when we have hearings are 2 or 3 days long and I'm meeting with the parents afterwards. As an attorney, do you meet with the parents afterwards? Do you prep them? Do you try to prep them at the very end to not give them too much time? Kind of tell us what that looks like.
So every case is unique, right? There are some clients that we've worked with for a very long time where their stories are part of my story, right? I know their children. I know their children personally. I can recall certain facts from 5 years ago because we have that relationship. When we're working with a newer family, my approach, which might not be everyone's approach, but my approach is to not over-explain, but do a lot of educating earlier on about what the expectations are. I want to know what to expect. I want to know what to expect tomorrow. I want to know what to expect next week. My clients want to know that too. And especially when you anticipate that there's going to be a high level of emotion and a lot of other things going on. And you mentioned the divorcing clients, that's not uncommon, unfortunately. And so if I can lay out a framework, but then also recognize that there are going to be contingencies that are outside of my control. This may happen. That may happen. I don't have control over what the impartial hearing officer does. I don't have control over what the district's attorney is going to ask on cross-examination. But this is what I expect. These are some things you can expect. I want to do that prep very early on. And I want to continue that conversation leading up to the hearing and then certainly after the hearing, because you're right. You may not always prevail in due process, but I want at the end of the day, my clients knowing I'm doing every single thing that I can to support your family. I'm doing every single thing I can to advocate for your child. And I'm doing every single thing I can to win the remedy that you are seeking, but I'm also here for you. And having that kind of a relationship, I think, is very helpful because they do feel supported. And in the unhopeful scenario that they do not prevail, they still have the ability to know that we've done everything that we could and they were a part of that process. I think that's very empowering, even though I'm not expecting them to be the lawyer. They're a part of our team because it's their child. They have to be a part of the team.
Now, do you, as an attorney, do you also attend and participate in IEP meetings regularly?
Great question. So it depends. So if we're working with families who are in public school programs or families are seeking services that a school district can award in an IEP that they can make provision for, then we often will, because if it's right for the family, right? But there is the potential for us to use that advocacy in the IEP meeting to get the result we want. The result that every single person on this podcast wants is for every kid to have what they need. And so if we're able to effectuate that without needing to go to due process and without needing to go to a hearing, you better believe that's what we want. There are some instances where, and this is more specific to New York City, but there's some instances where the school district has certain policies Well, we can't offer ABA on an IEP. We can't offer you one-to-one instruction. We don't have a different option. And so unfortunately, some of those families go back to that table that you talked about, Karen, every single year with the true bona fide hope that they are going to be given something that's going to work for their child. And they're not, over and over again. And so in those instances, it may not be fruitful for us to participate if we kind of can see the writing on the wall, unfortunately. But it is a very, very case specific inquiry, and one that we have with our client families, and talking about what their ultimate objectives are.
That's so good. We have in Texas, and I'm sure it's different everywhere, a list of mediators and a list of due process hearing officers, and you get who you get, right? And almost always they have been their attorneys, and they have been in this process for a while. In New York, if you file a due process hearing, is it just whoever's next in the bingo ball? You get who you get. How does that work?
You get what you get. That's what my 5-year-old says. You get what you get, and you don't get upset.
Right.
So in New York City specifically, within the 5 boroughs, the process is a little bit different than the outlying sections of New York. There are impartial hearing officers in across the state, of course, but in New York City specifically, there is a section of impartial hearing officers through the Office of Administrative Trials and Hearings. And those impartial hearing officers are full-time IHOs that are hearing these cases, and they are appointed. You get who you get, and you don't get upset. Or you do. But mostly, you are assigned to an impartial hearing officer. There is supposed to be a rotation, though there are provisions under the regulations that allow administrative changes if that's necessary. But we're also seeing such a tremendous number of cases being filed in New York City that there are times where multiple cases filed at one time are getting assigned to the same hearing officer for judicial convenience, or just that's the way the cases are assigned.
Yeah. So in New York, if you're going to file a due process hearing, so I always say it's about $30,000 here if you're the parent, give or take. It's going to take that long for the team, that whoever is representing you, to prepare. Is it usually about that many hours for your team to prepare for a hearing and then also present it?
Great question. So I would say that varies very significantly. There are cases that are significantly less than that are full hearings. We go to hearing, we're doing the evidence, we're presenting the case, we're doing summations, sometimes even written summations, and we're coming in under that number. There are also outliers that go above that number at just the initial administrative proceeding phase. And I think there are a wide variety of factors that play into that. Certainly the complexity of a case can play into that. There are some cases that are a little bit more straightforward. And a lot of hearings currently in New York City, the Department of Education isn't presenting witnesses. Not every case, but in quite a number of cases, they're relying on documentation to make their case. They're still defending fate, but based on documents alone. And so from a hearing prep perspective, you're spending less time because you're not cross-examining, you're not prepping for cross-examination. You're moving straight forward to your prong 2 presentation of the appropriateness of the program that you're seeking, or if you're looking for certain services, you're presenting that information and that evidence. And there are some cases where the school district will call many witnesses, and we will call many witnesses, and those numbers unfortunately can increase above $30,000 in some of those proceedings.
So as a round number of when you have a regular due process hearing, whatever that is, how many days do you have it? So for us in Texas, 3 days is pretty big. If you'd ask 4 days, it would have to be very, very complex, but it's usually 2 or 3 days. Obviously, the petitioner presents their case first, and then the school responds. But of course, cross-examination and all the things. About how many days in New York would you usually have for a hearing?
So currently, I would say the vast majority of cases are being litigated in 1 day. Sometimes that includes both sides presenting. In New York, the Department of Education bears the burden on FAPE on prong 1, so they have to prove that they offered a free, appropriate public education. And so even when they will call one or two witnesses, it sometimes is expected that the parents are presenting their case after the district rests. Certainly, if the district isn't calling witnesses, it's pretty easy to be able to get through a case in one day because you're just presenting your side. You know your side, you know your information, you know what points you're trying to elicit. The other thing I'll also note is, in response to my earlier question about the impartial hearing officers coming out of the Office of Administrative Trials and Hearings, that move was just made within the last few years. Prior to that, testimony in hearings was almost always live testimony. So I am going to call a speech therapist and I am going to start my questioning by asking for their background and their license and go through the whole song and dance of question and answer to present that aspect of my case. Currently, we're using affidavits. Almost all the impartial hearing officers either request or require affidavit testimony. So from the cost question earlier, that can become costly because we're incurring a lot of expenses in advance of hearing, asking the questions, asking follow-up questions, asking the witness even more questions with respect to their affidavit. But the actual hearing itself can move quite quickly because a lot of that information is in the record already. Those affidavits are evidence, and cross-examination is just stemming from whatever affidavits were provided.
So are those interrogatories, are those depositions, or does your state allow both?
So typically we're not using either. We are having in New York City, we are having witnesses provide affidavit testimony, and we're asking those questions, right? And having them review documentation and essentially putting together their opinion, professional opinion, as to what the student's needs are and what is an appropriate remedy if that's what we're seeking.
So good. And we're going to open up in just a sec for questions. I know you guys are excited to get to them. One of the things that I hammer with people is you've got to get the paperwork right. And so when we come out of an IEP meeting and we're upset, sometimes parents don't even get the paperwork. But when they do get the paperwork, talk about how unbelievably important it is for them to review it. And then if they don't agree with the components of it or the deliberations, which are written by the school district, how important it is to respond in writing to what they're saying.
Oh, 100%. So they need to read it. We need to read it. We need to reread it, right? You want to see if it accurately captures what transpired at the meeting. You want to see if it's accurately capturing what you communicated as concerns. Just the other day, I was looking at a report at an IEP, and I was comparing it as against the parents' notes from the meeting. And there was so much of the IEP, Karen, that followed exactly what the parents' notes were, the present level section and the review of the evaluations and everything. And then it gets to the parent concern section. And in sum and substance, to a lay person who knows nothing about special education and has no special education child in their family that they've had to advocate for, they might be like, yeah, they're similar. Okay. But the word choice and how the parents' concerns were framed, the parent really wants what's best for their child. That's not what the parent said. Parents said, my child needs this in order to learn. Those are two totally grossly different sentences. And so if you're not reviewing that, and then you're not documenting in real time or relatively contemporaneous in time, that there are concerns and problems within their own document, it's almost like they've accepted it. It's almost like, okay, well, you didn't say anything. What, now you want to come to due process? Now you want to sue us? And now you want to say that's wrong. So I do think it's really important. Not to mention, I by no means am sitting here saying that school districts are trying to trick parents or get parents into, a slippery slope with wording. A lot of times, maybe it is an innocent mistake, but if it's not getting documented, again, it goes back to your memory is only as good as your memory is. But if you put it in writing, it's documented, it's there, and it's evidence.
Yeah. I love the Miss Cunningham. We're going to have to agree to disagree. And I promise you, I say this every time. I said, well, I can't agree to that because you're mistaken. Right. This whole like we're at some sort of barbecue, we'll have to agree to disagree. No. And that when the language, your words are everything. Right. Because this is going to be in front of a stranger. Right. And so I'll have clients that reach out to me and need an advocate. We've gone back and forth with ABC School District for years. I get the paperwork. I prep the whole thing. I literally don't see a single disagree. Well, I mean, my kids go to school there, so I didn't want them to be upset with me. Like, if you're going to disagree, you need to capture it. As we all know, if it's not written down, it never happened, right? And kind of
Right.
talk about how parents, always say they have an unholy alliance with the school districts, right? We all did that. Talk about how important it is with sobriety to get the parent's position, even if it's a response to a meeting they were in.
Sure. And to your point, we have a lot of clients who have kids who are in the same school, right? So, but I think in connection with your question, it's not so much a matter of making the district your enemy, right? And sometimes we advise clients and we say, listen, the agree to disagree, they're not going to agree with you. They don't agree with you, but there is a very professional appropriate way of communicating your concerns and being disagreeable without or disagreeing without being disagreeable, right? And communicating what the concerns are in writing.
So good. In New York, do your IEP meetings start out with, we have to read the norms. We're all going to act nice in a conversational tone. Nobody will attack this. I mean, just, do you have that?
No.
And then they always say, everybody raise your hand that agrees to that. And I look around, I'm like, I'm not, I don't, I'm like, I sit in lots of business meetings. Nobody's ever like busted out. We're not going to attack each other. Okay.
No, that does not happen, thankfully. Oh
We'll
my
have to send you a
goodness.
copy of it. It's like, raise your hand. So, well, thank goodness. I'm going to open up for questions because I know we have so many. Thank you so much for being here. We have no idea how much we appreciate it. So, Jerica said, would you have become a civil rights lawyer for special education, or can you share what your further education journey looks like to become a special education lawyer?
So, if I'm understanding the question correctly, did I want to go specifically into special education or civil rights more generally? I think there are pros to doing both. I'm not sure that there are cons to doing either. From my vantage point as having been a teacher in a class with students, my very first class, well, my very first class after I was hired to be an ABA teacher about 2 weeks out of graduating from college with a politics degree. But my very first class experience was teaching 6 students with autism who had 6 totally different levels of need and levels of strength. I'm one human with one classroom paraprofessional. We cannot possibly be meeting all of those needs every single day and doing right by all of those kids. So for me specifically, I wanted to tackle the special education aspect of it, but certainly that's not separate and apart from being, in my view, a civil rights attorney, right? Because we are here advocating for the rights and entitlements of children who have prescribed entitlements under the law. And so I think there are other attorneys who've gone into other aspects of civil rights representation and litigation, but my specific desire was to do special education.
Awesome. A parent asked, how do families get funding for due process if they can't afford an attorney or an advocate for that drawn out process?
That's a great question. And it's one that's currently being talked quite a bit about in our state and in New York City specifically. Because as you point out, Karen, this process can be very expensive. I know that there are some firms, including our firm, that are able to take on some pro bono cases and even maybe low bono cases. There are some firms, not ours, that have historically taken on many, many pro bono cases with the idea that if they are successful at due process under the fee shifting entitlement under the IDEA, they can seek fees from the school district if and when the parents prevail. But that relies on prevailing in due process. And there are a lot of attorneys who can't or do not want to build a practice based purely off of contingency, right? So we have a number of families who use a variety of means. Parents will take out loans. Parents will borrow money from a family member. Parents will go on a payment plan or some kind of scheduled payout to be able to find services. And there are quite a number of resources through various organizations that are able to provide representation to families who are in need.
Right. And that's really different across the United States. We are in the Fifth Circuit. We are good at football and cattle and, raising chickens. So every state is different, and those resources are very different. I would reach out to your DOE or your special state education agency and see what those services are, if that is something that can help you. So somebody said, currently, my school district only has one middle school. I do not want my daughter to attend because of the school. I know the down and dirty. My district offers an alternative school for K through 12 hybrid model. My application for my daughter was denied because my daughter has an IEP. I was told at her IEP meeting that I recorded that there's no room for kids with an IEP. Due to staffing issues, she can't attend. If a public school receives federal funds, can she be denied?
It's a complex question with a lot of parts. I encounter this quite a bit, and certainly I've encountered this in my own family as well in our IEP meetings, where if you have an IEP and you need a certain program, you're going to this school, regardless of whether the school that's right by your house is right by your house and the school that your child would otherwise attend. This is a question that comes up quite a bit, and parents are trying to advocate for the right program that's going to support their child. So I would look into the middle school that you're trying to not have your child go to. I would identify what the reasons are and what the evidence and proof is to support your reasons for your child not going there. I would ask to do a tour of the school and see what it actually looks like, and be thinking to yourself when you're in the building, what is not going to work about this environment for my specific child? Those potentially could become substantive deprivations of FAPE if they are not going to align with your child's needs. But a parent's desire to simply want to go to one school over another alone may not be enough to support the district actually agreeing. And again, it also raises the question of, when you're in that advocacy stage of trying to resolve a dispute, you're also relying to some extent on the school district acknowledging what your concern is and being willing to resolve it, right? And if that doesn't happen, then advocacy may no longer work for you.
Yeah. Kiddo in 7th grade, 85 IQ, many eligibilities, and he's reading and writing below 3rd grade at a 4th grade in math. Is the grade level discrepancy proof of a need of FAPE? Is lack of progress proof of FAPE? Nassau County, New York.
So I think it's certainly something to investigate and look at for certain. I think it's a little bit more complex than that. So I think you want to look at historically what kind of progress has been made. If the school district is saying there's progress, is that meaningful progress? There is probably many of you here know about the Andrew F. case. The Andrew F. case heightened the district's ability to say, well, merely de minimis progress is enough. No, it has to be meaningful progress, and it has to be meaningful in light of your child's unique circumstances. So when you look, I would look at the IEPs year over year. Are the goals the same? Or are they different, but they really are the same? They're just reworded differently. What do the report cards look like? What do the evaluations say? Have there been evaluations? Is that IQ score and the reading and math levels coming from a formal evaluation, or is that coming from informal assessments conducted in the class? And then is it time to potentially call in an independent evaluator and request an independent educational evaluation from your school district to have that unbiased third party come in and really get a sense of what's happening? Is this appropriate? Is your child making appropriate progress? But I think looking at that progress piece is going to be huge, because you could have a child who is above grade level in reading and math, but their other disabilities and their other areas of need still make the environment that they're in not appropriate for their needs. Then you can have kids who are very significantly delayed, but they are making meaningful progress for who they are. So it's a very, very highly individualized analysis.
Yeah, that's appropriate in light of their circumstances, right? So
Exactly.
there's several questions in here that are specific to me, and Texas. So if you guys have questions for myself, just email us at advocate@specialeducationacademy.com, and we'll get to those. Make sure that you get a response to those. So Kathy says, is it true during a due process, the school district attorney can throw your past personal records at you? For example, if you filed bankruptcy or had any other record, can they bring it up? So Kathy, it comes up for me a lot. It just turns into the advocate, and I've seen it in filings, and the hearing officer lit up the district attorney. They did. And again, it's about what is the question before the court, but I will let the great Maria answer that.
So I will say that typically does not come into our due process proceedings. There have been instances where, in my personal opinion, one or two school districts attorneys have taken it over the line in asking personal questions or trying to elicit personal information like that. I remember litigating a case once, it was in federal court, and the school district had received a copy of a document that listed an address that was other than the parent's address. And they went on a residency crusade saying this family can't live here and this can't be happening. And look at their apartment and there's only X number of bedrooms and there's Y number of kids. It was unlike anything I've ever experienced before or since. So can it happen? It can happen. Should it happen? I think to your point, Karen, a lot of hearing officers and a lot of judges are going to be really turned off by that approach. You don't get bees with vinegar, you get them with honey. And I don't think that that's the right approach. And thankfully we don't encounter that too much, but I guess nothing can stop someone if they're trying to make an argument.
It's important to know, as somebody that's been in court for, ending a marriage and custody, nobody's nice in court. Nobody's going to go, Maria, she's the best this is the best mom we've ever. It doesn't go that way. Nobody leaves going, this was a great day. And so you have to remember that. Somebody says, as an advocate, what can I do to make sure that I don't inadvertently weaken a possible due process case down the line? So we would call that, don't clean up the document too much, but can you speak to that, Maria?
Sure. I would say probably the best advice I have is when you feel like you're getting out of your comfort zone, you may be out of your comfort zone. And also having strong connections with attorneys in this field is going to be an invaluable resource, because not only can you engage in a lot of back and forth collaboration or discussion generally on topics that are coming up, you can also gain information about what's actually happening here and now in the world of due process. But I do think that advocates serve a tremendous role and are extremely effective and necessary for many, many families. But when you're getting into a territory, and most oftentimes when we're contacted by clients who are working with an advocate, it's oftentimes the advocate that's saying to them, listen, you might want to have a conversation with a lawyer. We're starting to get to a line that maybe you're going to need to transition. So I think having that sense of, am I still trying to accomplish something that I can accomplish? Then you're still probably advocating for that child. But if you're trying to accomplish something and there is no give in the conversation, it's likely time for a lawyer to get involved.
All right. When the question says this person has spent thousands of dollars on advocates who unfortunately were not equipped in special education law after exhausting informal resolutions, complaints, and other avenues, I'm now pursuing a special education attorney as a last resort. I've also found that many advocates are unwilling to participate in due process hearings. In your expertise, have you seen non-attorney advocates successfully support families through due process and contribute to favorable outcomes? If so, what qualities or expertise make those advocates effective?
That's a great question. That's an excellent question. So in New York, there are advocates who do represent families and children in due process proceedings. And there are a number of them who have been very successful in those cases. But I also think it requires an individual analysis, right? I might not be every single person's cup of tea, and the same might be true of every one of my colleagues, right? So you want to find the right personal match. You want to find the person who's going to do right by your family, by your child, who knows the ins and outs of where you live, what the practice looks like there, who the players are, what the expectations are, what the rules are. There's not, just because I have a law degree doesn't make me any better than any other advocate who's in New York who's doing the same thing that I do. But it's knowing what you need to know and doing that really, really well. There might be some advocates who are better than some lawyers out there, right? I'm not saying that specifically, but that could be true. It's just a matter of finding the right match and finding somebody who's going to do a very diligent, effective job.
Yeah. Okay. So after filing a state complaint, the state ordered a corrective action plan. The schools missed the deadline and delayed. Is a due process or mediation appropriate for this situation?
So it may be. There are certain exhaustion requirements. I think it's going to be a little bit case specific, and I don't have more detail, so it's a little hard to definitively say yes or no. I think you would look at what the requirements are in terms of compliance and timing. It may be a possible remedy for you, but I think it would depend on what has transpired already.
Sure. I don't really understand this next question completely, but it says I've been trying to get a case for years. No one would take it. I just got a firm to say yes. What am I looking into? So I don't know, Dwayne, when you say, are you looking into like financially or time? I would need a little more information about that. Let's see. Carlos says, my daughter's school will restate the IEP goals and tell me that she is working towards her goals for her progress reports. They will state that she's met 50% of her of her goal 2 out of 3 times. Her grades are very good, but she has speech, advocacy, and counseling IEP goals. I'm not really sure. Carla, if you can write me a question, then I can come back to that in there. Diana says, how do the IEP goals live within the TEKS, the Texas Essential Knowledge and Skills that need to be taught? My district presented curriculum well above my students' level because she's profoundly deaf and does not know ASL. She's now going into 6th grade, functionally literate. Can the district be held responsible if her IEP goals are supposedly being met by the presented data? This cannot be trusted. I'm going to just answer that a little bit. So in Texas, which would be in any state, you have the state standards, right? In Texas, we call ours TEKS, and they're supposed to be aligned to them. They're not exactly them. If they were meeting their state standards, it would be an IEP. But it's not about, nobody's going to come in and investigate the school's IEPs, right? So when you say this can't be trusted, I think kind of what Maria talked about before is I use the TED framework. Tell me what that looks like, explain what that is, describe. I think that people need to spend more time at the beginning of an IEP meeting going over the IEP progress reports and populating a pristine, prescriptive, puffy PLAF. And we rarely do that. And then in those moments when you have other data that supports that these numbers may not be totally accurate, that's where you open up that question, right? But no state's going to go, oh, I don't trust ABC school district. Go get them. It doesn't work that way, right? It's a good question. Let's see. What are the chances of winning? A child was restrained, have video without an attorney. Let me just speak to that for a second. So I just want to say respectfully, it's not about winning. We want the parent that we represent or are supporting to prevail. But I have had IEPs and due process hearings where there was video, audio, the SRO standing there, the principal standing there, the nurse is standing there. And we prevailed, but then the district appealed, right? So kind of talk about what that's like for, and this had some physicality with adults and the disabled child. So kind of talk, Maria, about, we won, we got confetti, we couldn't be happier, we're popping champagne bottles. And then within 90 days, the district has the option to, of course, appeal, right? So kind of talk about what that looks like.
Sure. So I think for starters, I don't know that any family is doing a popping champagne bottles even when they do win, right?
Right.
Because at the end of the day, nobody wanted to take this avenue in the first place. No parent is sitting here saying, "Ooh, isn't it glamorous for me to go to due process?" Nobody wants this ever.
Right.
But then when you do go and you win and you do somewhat feel vindicated as a parent, like I knew there was a problem, I hired a lawyer, we litigated the issue, and now there's been a remedy that's awarded to my family, and that is really meaningful for my child. And then there's an appeal. As a parent, it feels like a huge stab in the gut. Like, come on, we just won, we just presented our case. But then you're also talking about financial implications, the ongoing emotional toll, and then going through a process where on appeal, you may continue to prevail, you may not. And the uncertainty of that is very anxiety producing, I think, to many families. I have represented families on appeal and on appeal all the way up to the Second Circuit, and then on remand all the way back down. I've represented one family through 8 stages of litigation, from the initial administrative trial to the SRO to federal district court to the Second Circuit, and then back to federal district court and back to the SRO and back to the impartial hearing officer. Who wants to do that? By the way, we also, at the end of the day, if we're prevailing or if we're settling, we don't want to even be asking the school district to have to pay those fees under fee shifting, because this is probably a situation that should have been resolved in the first instance. But I think, again, going back to what I was saying earlier and having these really hard conversations or real conversations really early in the process and telling parents really what they can expect. That's a part of the expectation. There's always risk in litigation. And even when you get the win, until that appeal window is done, there's a risk of potential appeal as well.
Right. That's good. Do you see BOCES in New York eliminating hands-on intervention and isolation? I would consider this an alternative placement that I was offered for my child only if I knew no one would put hands or isolate them to see other children or see other children restrained. He has a trauma history, and an overactive amygdala.
So BOCES is a program that's available to students that school districts can recommend. It's considered an out of district placement because it's, but in any event, I have had some families go to BOCES programs and been incredibly encouraged by how great the program is. I have other families who have been very concerned in viewing those places. So if it comes to the restraint process that's used, that's something that definitely has to be assessed by you as a parent prior to placement, with the hope that you're able to get into that BOCES program, see it, evaluate it, and ask a lot of those, I like it, TED questions, right? Explain to me how this works. Describe the process. Can we see this? And again, evaluate what that looks like. Every student's program should be individualized for their specific needs. So do you have an IEP that already comports and aligns with your child's needs? And then can that be effectively implemented in a potential BOCES program? Those are the questions I would be asking.
And just to respond to that, the state or the district or any entity must have some sort of intervention in place for a child that does need to be safely restrained. That's never going to go away. That's not going to be something that the district can ever go, oh, we promise you that's never going to happen with you or your child. Obviously, it should be done with care, but that would be something that, we also have to think about the other kiddos and their needs. So how does the restructuring of the Department of Education impact hearings, mediation, and compliance? And then additionally, did you see the update? This is just me, Maria. Did you see the update today that we're adding DOJ and HHS
Yes.
to those pieces?
Yes. So I think there are quite a number of clients that we have that ask this question. And what does the current administration, or what are current things that we're seeing and hearing about, what impact does that have? And I think there are a number of ways that you can look at it, but I think what's most important is to recognize that disability is something that crosses both sides of the aisle. It's something that impacts everyone. And it's something that really needs to be looked at and focused on. And we're really looking at an individual child's rights and entitlements. I do think that there are parents who have voiced concerns about what is taking place and what could potentially unfold. But with the passing of each administration, there are changes that transpire. And I think it remains to be seen exactly what the impact is going to be on the ground.
I'm an educator in the classroom. I'm required to go through an OT packet about 1.5 inches thick, or things to try before I'm able to refer for OT. How do I get around that?
Can you repeat the first part of that question?
Sure. She's an educator in the classroom. She's required to go through an OT packet about 1.5 inches thick, and try things before I'm able to refer for OT. How do I get around that? So I think that it's sort of like the OSIP letter from January 2011, that we can't have school districts making you do something else to stop testing, but I'll let you speak to that, Maria.
Right. So I think that if you're an educator in the classroom and you're looking at a child who potentially needs occupational therapy to be able to access learning, you're knowing that without necessarily reviewing 1.5 inches thick packet. But I also think that there are situations where educators' hands are tied. And so it's a matter of voicing your belief in the student's strengths and also the student's needs, and talking with administrators about the need for an evaluation. Every district is going to be a little different. Listen, towards the end of my tenure as a special education teacher, I felt very comfortable stating the truth in all of the meetings, knowing that I had one foot out the door. And somebody told me, well, you don't have tenure. And I was like, I'm right. I don't have tenure, and I'm not going to be here, and I'm going to do other things. Okay. So I'm going to tell the parent, your kid's not getting speech therapy because they're not getting speech therapy. Right. But also recognizing that that might not be everyone's position and the role that everyone wants to take, and understandably. But if a child needs services and you're suspecting that they need those services, you should feel comfortable advocating for that without necessarily sitting there and reviewing voluminous records that are going to somehow get you around an evaluation. It sounds like what might be happening.
Yeah. So we just so Angie asked, can you elaborate more on New York having the burden rest on the school that they provided a FAPE instead of that being on the family to prove that FAPE burden? Explain how this shifts the dynamic. So, and also, I'm sure you know this, Louisiana just picked it up, and now they have shifted that. I wasn't unaware that this happened anywhere, but when did it start in New York, and how has that impacted due process outcomes?
I don't recall this date specifically. It's been that way for quite some time. But New York State, the Department of Education attorneys are required to prove that they offered a free, appropriate public education. In practice, what does that look like? Well, in some of our hearings where the DOE is not calling witnesses, they are presenting documents. They're presenting an IEP. They're presenting evaluations that were available to the IEP team. And they are relying on that documentation to meet their burden. Now, obviously, under Andrew F., the court was careful to note that impartial hearing officers should expect a cogent and responsive explanation for the decisions that were made by the school district and what they did and what they didn't do. So a lot of times I'd be walking into a hearing at the outset without a witness to say, nobody's here to explain all of the 59 enumerated points we have in our complaint about allegations as to why this IEP is not offering the child a free, appropriate public education. In other instances, the Department of Education may call witnesses to support their IEP, in which they're asking questions. Again, noting earlier this unique affidavit testimony situation that we're in, some of those affidavits leave a lot to still be questioned. And they might be an affidavit that's 8 sentences long that says, this IEP offers a FAPE. Okay, why? How? What is it doing? Yeah. But the district bears that burden. And so part of obviously we're presenting our case to show support for the remedy that we're seeking, but a lot of times we're also preemptively identifying why what the district has done or hasn't done is not appropriate for the student's needs through our own witnesses. But the district ultimately bears that burden. And sometimes there are hearing officers who will acknowledge, you haven't met your burden. You gave me an IEP, but you gave me no explanation whatsoever as to how this IEP and everything that's in here is aligned with this particular child who we're here talking about. And so therefore you fail to meet your burden.
And so is that, do you know how many states that's in? Because I didn't know it was in any state. But it really would shift things, right? Because, the parents are, even if they're attorneys in that moment, they're the layperson, right? Is that something that we would have to get addressed at like the state legislative level?
Yes, that is true. And listen, it does change things pretty dramatically because when you are litigating in states where the parent bears the burden, it's like we're taking the party out of the two parties. We're taking the party that has significantly less resources, significantly less access, who has been aggrieved and then needs to go forward and bring this case. And then they have to show how the school districts failed to offer a FAPE. Maybe that's because I've been practicing too long in New York and I'm very accustomed to the DOE having to bear that burden. But it does certainly create such an additional set of hurdles for parents to have to navigate when they are responsible for bearing that burden of proof.
Yeah, it makes that, I don't know, that makes it not really fair, right? Sarah
Totally.
says, our state has a school for the deaf and blind, which is the state's educational agency. Few students actually attend these schools, but many students are service and outreach settings in both public charters and districts. What should a parent expect when they exercise their right to the procedural safeguards after filing a state complaint? Is it possible to have an impartial hearing in this scenario? If so, what does that look like? So just for this, those are two different things. A state complaint, you wouldn't have a hearing officer, but a due process, you would have a hearing officer.
Right. And so I think there are, in full disclosure, we have done state complaints before, but we do not do them very regularly. Almost always the reason behind that is because we are able to seek the remedy that our clients are looking for in the impartial hearing process, and that may happen quicker. You're going to need to look to your jurisdiction to see what those timelines look like, and then on the ground, how those timelines are actually running, right? Because there are always deadlines in compliance states. That doesn't necessarily mean things are always happening by a compliance state. There are extensions, there are delays. And so I think you want to identify what relief you're seeking, if it's something that you can get through the impartial hearing off the impartial mechanism, and if that may happen faster, because a lot of times lost time is one of the worst things that can happen. And so if you're faced against something that can take 2 years versus something that may happen in 5 months, that alone may be reason for you to consider an alternate avenue.
Is there a particular age group of students where due process is filed?
So under IDEA, students are entitled to a free appropriate public education until their 21st or 22nd birthday. And we are representing clients from ages 3 through 21, 22. There are mechanisms for parents who have children who are in early intervention to dispute those services or the lack of those services being offered. We personally don't handle those cases, but we're representing clients who are as young as 3 or 4 years old and as old as aging out of the special education system.
When you're at an IEP meeting and they ask you about a different school for the following year, but they decline it, should that discussion be in a PWN? Oh, the PWN.
Yeah. Well, it certainly would be recognized in the IEP. Should it be considered in a PWN? I think that if you're considering something and it is being rejected, it's something that likely should be considered in the notice, because the whole point of the notice is for you to have written notification of decisions that were made with respect to services and offerings. Practically, an opponent of mine might make the argument, well, you received the IEP and you received the PWN, and the rationale for rejecting an alternate placement was in the IEP. So you were on notice of it because we gave the explanation within the IEP document. I think I've yet to see a PWN that really includes everything that I think it should include.
That's amazing. That's what I say. Yes. Yeah. Or our friends across the bay who like to say, and in Texas, this IEP and the deliberations constitute a PWN. They don't ever. I've never seen that happen. But anyway, I've had parent concerns. So Jamie said, if they don't like the parent's choice of words, can the school district dictate what is put in the deliberations? So Jamie, I'll just, from doing this for 3 decades and 500 a year, it's rarely, especially when we're not agreeing on things, it's rare that the person typing that is going to type literally everything that you said. And like Maria said, they're just trying to summarize it. So what I do is when I receive the deliberations, I respond back with our understanding of today's events, right? So that it's attached to the record. It's part of it. I don't find going back and forth and saying, Maria, change this and then add that over email is effective. But what would you say to that, Maria?
I agree. I think if it's something egregious enough or something that's factually grossly inaccurate, that should probably be changed, because an IEP is really the roadmap and the mechanism. Anybody working with a child should be able to pick that up and know exactly what needs to happen, or almost exactly what needs to happen, right? So if there's information in there that is grossly inaccurate, that can impact an educator or a therapist's ability to appropriately address that child's needs, like, that should definitely be corrected if your child is going to be in that program and that IEP is going to be implemented. But if there are language nuance issues that I mentioned earlier, I would document it exactly as you said, Karen. I don't think I would go back and say, can you change this? Can you edit this? Can you do this? Can you do that? Just do a write-up. This is what happened. These are my notes. This is what transpired. These are my concerns. And the ball is now back in the district's court.
Right. I've had parent concerns continue in the document each year to document longstanding concerns. This year they said they were all removed. Any reason why they may do that? I'm waiting to hear back from the case manager to put them back in.
I think it's an interesting question because every district does things a little bit differently. There are districts that are in New York State, but not in New York City, that will include documentation from prior IEP meetings. Certainly in New Jersey, that happens as well. You can look at an IEP, it's like 116 pages and it's going back 5 years, right? Everything that's been said for the last 5 years is in there. Whereas in New York City, every IEP is pretty much a standalone document. Like, this is what we talked about, or these are the present levels of performance now. There's very rarely significant historical information in that IEP document. I think it depends on what your ultimate objective is. Are you concerned that you're going to a hearing? One of the things I'd be thinking about is, am I concerned that I'm going to go to a hearing? The Department of Education or the school district's attorney is going to say, well, these documents from 2021 are irrelevant because that's not the year at issue. And so those should be excluded, with the risk that an impartial hearing officer may exclude them. And then therefore the contents of those documents are not in the current IEP document. If part of your argument is to say there is a long-standing history of failure here, right? But if you have the documentation from prior IEPs and everything that you want to have is in there, then I would make the argument at a hearing that those documents are certainly relevant, have very specific examples of why they are relevant, and ask for them to come in as well and say, listen, maybe you even put that in your letter to say, I participated in the meeting, then I got the IEP document. And by the way, everything that used to be in there is out of there. It's only new information. And I think it's relevant to have the prior information in there because that's showing where my child has been, where my child is coming from. It may be relevant to progress, etc.
Yeah. So I'm going to try to ask a few more questions. I don't want to keep her here all night. You guys have really, really good questions. Somebody said, how long after the meeting do they have to post the IEPs?
So in New York, there are clients who get the IEP meetings the same day, a few hours later, There are some clients who never get a copy of the IEP. And those are some public school families. They don't ever get the IEP. So it's reasonable to expect that the district is going to need to summarize the IEP meeting, include information. There may be evaluations that were discussed, and information needs to make its way into the actual IEP. We also don't necessarily want school districts creating IEP documents before the IEP meeting, because that's precluding meaningful parental participation, right? So we have to expect that there could be some time for school districts to finalize an IEP and get that out to the family, but that has to be reasonable within a reasonable period of time. There may be different timing requirements in different jurisdictions, but it can vary.
That's good. I just got accepted into COPA seat, special education advocate training, and then became an attorney in the future, and then become an attorney in the future within the same field. Would becoming a special education advocate would stand out in law school applications?
I'm not sure. I think it could be. I think if you're going to apply to law school and you know this is the area in which you want to practice, I think it certainly could be helpful to have those advocacy tools and use that as a way of kind of explaining your background and why you're applying to law school. But I think it would really depend on the admissions committee.
Do you recommend personally recording every IEP meeting, and can those recordings be used as a paper trail or evidence in a hearing?
So different states have different recording requirements. Some are one-party states where one party can record a conversation without giving notice to another. Some states you need to notify someone that you are recording them. By and large, I would say my own professional approach is if you're recording an IEP meeting and you intend on using it at a hearing, you definitely need to let your school district know that you are recording them. But I don't necessarily encourage clients to record IEP meetings, depending on what their objective is. If your objective at an IEP meeting, which is what it should be, is to try to get an appropriate public program for your child and actually address your child's needs within the IEP document, why are you recording the meeting? Are you recording the meeting so you can catch somebody in something? And then also, does the existence of the recording itself create a chilling effect? Which, to one of the questions you asked earlier, Karen, do you participate in IEP meetings? Sometimes having an attorney is helpful. Sometimes having an attorney is a chilling effect, right? But I think recording IEP meetings could be the same thing. Sometimes parents what I've seen some parents do is record it, but just for their own personal purposes. They have no intention of ever using that in a due process proceeding. But they're one parent going to an IEP meeting, sitting at a table with 10 other people or 5 other people, right? That's overwhelming in and of itself. So sometimes they're recording it just to be able to go back and say, well, what did they say? Did they say it was the 3rd grade level? Did they say it was the 4th grade level? I don't remember. Let me go back and check. But I think that is a very case by case specific question. And I think you also need to look at what objective you're trying to achieve by recording the meeting.
That's good. Let's see. I'm trying to get through. If an IEE has been approved and parents believe the IEE should be provided by a neuropsychologist, the child appears to have multiple undiagnosed disabilities that impairs the child's learning, and the school's evaluation had different findings, can the family insist on a neuropsychologist versus an LSSP?
Go ahead.
Yeah. So probably, Connie, you're in Texas. I would really caution my clients on asking for something that didn't get evaluated, right? We don't have neuropsychologists working in school districts in Texas. So for me, if you're wanting an IEE, it would be the same credentialed provider doing that IEE, but it sounds like you're wanting a neuropsychologist, which is not a requirement in the state, but I'll let Maria answer that.
So we get this question quite a bit. There are a number of families who believe that a neuropsychologist would be better positioned to assess their child's areas of need, make diagnoses, and then make recommendations that are coming from and aligning out of those areas of need and diagnoses. There are families who have asked for a neuropsych as an independent educational evaluation in New York City and New York State and been awarded that. Under the law, if the district is not agreeing to give you an IEE, they would need to proceed with due process against your family. That very, very rarely happens. I have seen it happen, but I haven't seen it happen in a very long time. What does, though, often happen in New York City is that parents will make a request and it just goes unanswered. And so then you don't have a yes, you also don't have a no, and then you're stuck in limbo. But making that request may give you the ability to try to get a neuropsych either out of your own pocket or through insurance or through another mechanism and say, listen, we tried to have the district give us an independent, agreed upon neuropsych to conduct this evaluation, and our request went unanswered.
Okay. A lot of you guys have very long, complicated questions, and we're going to give you Maria's information at the end. So we're not reading them. Some of them are just very long and complicated. So Tracy asked, where do extracurricular activities fall under either IDA or ADA?
So under ADA, any extracurricular activities need to be accessible to any students with disabilities. Under IDEA, services that are necessary for a child to make meaningful progress are what needs to be provided to that child. That term extracurricular often denotes that there is an extraness about it, right? So there's horseback riding, or there's swimming lessons, or there's soccer. And those are things that a school district does not necessarily need to offer a child. But there may be certain activities that happen outside of a school day that a child needs to be able to make meaningful progress. That is a highly individualized analysis. But if there are services that are needed beyond the school day for a child to make progress, then those are services that would need to be provided to that child in order for that child to have a FAPE.
Perfect. And then I'm going to finish on this question. I know you guys have so many of them, and we really appreciate you being here. And we'll have the great Maria back. Jen says, how often have you seen a class action case against a school district? The district has program managers that have been on waivers for years and case managers that have no clue how to write an IEP or run a meeting. They also change placement and use in personal parent account to change authorizations for children. It's a systemic problem.
So first and foremost, if you're considering a class action lawsuit or considering being involved in a class action lawsuit, you need to be working with counsel that is very, 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 very comfortable in that space. I, at one brief point in my career, did work on a class action lawsuit for a portion of that proceeding. But you really need to have counsel that knows the ins and outs of that. There are a few class action attorneys operating in this space in New York, and they know everything, the ins and the outs of exactly how to bring that case, exactly what should not be included in class action lawsuits. They have knowledge and experience in terms of really whittling down what the one, maybe two issues are in that question alone. I think there were 3 or 4 or 5 potential factors to be considered. And so you really need to have counsel who's looking into identifying what perhaps the largest or the most likely to succeed issue is. And then again, operating within the framework of having significant class action experience. I can't hear you, Karen. Sorry.
There we go. It was really important what I said. I'm going to throw in one more question because we get it all the time. How can we advocate for policies that could protect teachers who speak up?
It's an excellent question. So I think there are a few things that can happen. First of all, the teachers banding together and working together is going to be huge. It's really hard to be one voice in a sea of many and being the only person who is saying or alleging that something has transpired. I also think that parents and community involvement is critical in identifying what the issues are. There are a lot of different means in terms of getting that out there, whether it's writing letters to the editor or exposés or things of that nature, but really getting to the bottom of supporting teachers who are willing to be so-called whistleblowers. There are also many attorneys who do represent teachers in that regard, and can probably counsel teachers through how to navigate speaking up for children's rights and what the right thing is without compromising their professional status.
Well, Maria, thank you for being on. We would love to have you back in the future if you'd be willing to do that. If people are wanting to reach out to you for your services, consultation, or consideration, how can they best reach you?
Thank you so much, Karen, for having me. It was amazing to be here. Yes, so you can come to our website. It's mlgsped.com. My email is maria@mlgsped.com. And I'd be happy to answer any questions from anyone who didn't get their question asked today. And thank you again so much, Karen.
Thank you. Yes. And thanks, you guys. We appreciate all the questions. If you have something specific for us that we can help you with, always reach out to us at advocate@specialeducationacademy.com. Remember, always, we get it right for the child, we get it right for everybody. And we'll see you guys in the next training. Hit subscribe, share this with a friend. And you know what? Meet me back here every single week. We're not just talking about change, we're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody.